Definitely, 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 definitely a violation of Turner v. Driver. No, dude, read your own decision and understand it while you're doing it. This is from Turner v. Driver. I'm going to mark it so I don't lose it. Can't mark it. Damn it! Damn it. All right, we're about there. Turner v. Driver. There you go. Oh, noes. Oh, it's still there. Yay!
The internet's smarter than I am.
All right, so as the First Circuit explained, the filming of government officials engaged in their duties in a public place, notice that, in a public place, including police officers performing their responsibilities, fits comfortably within basic First Amendment principles. This right, however, brace yourself, is not without limitations. Like all speech, filming the police may be subject to reasonable time, place, and manner restrictions. In this case, however, we need not decide which specific time, place, and manner restrictions would be reasonable. Nonetheless, we note that when police departments or officers adopt time, place, and manner restrictions, those restrictions must be narrowly tailored to serve significant government interests. That said, to be constitutionally permissible, a time, place, and manner restriction need not be the least restrictive or least intrusive means of serving the government interest. Now, if you've been paying attention to all the videos I've made, you've got a lot of little alarm bells going off. Number one, you're aware that Mr. Turner was arrested on a public sidewalk, and a public sidewalk is a traditional public forum. The inside of a police station is not a public sidewalk, nor is it a traditional public forum. In fact, if the classification of that building as a courthouse does hold up, and it very well may, I'm not saying it will, but it does fit the traditional dictionary definition of courthouse, so there is a very good chance that it will. Courthouses have been ruled as being non-public forums, so they are the antithesis of a sidewalk. Police stations probably will fit in. Adderley v. Florida was a jail. Police station will probably be something akin to a jail, I'm guessing, unless there's some state law that, or state statute or state case that holds it to be some sort of a different forum for First Amendment analysis. But the time, place, and manner restriction and the narrowly tailored to serve a significant government interest should ring some bells. Time, place, and manner restrictions are what you see when you're dealing with traditional public forums. It's an intermediate scrutiny kind of standard in general. The government must show that the law serves an important or significant, it's interchangeable, objective, not involving the suppression of speech, and the law is narrowly tailored, and therefore, and that there remain ample alternative means of communication. What are they citing there? Narrowly tailored 52. 52 is McCullen v. Coakley. Well, that sounds familiar. Look, there's McCullen v. Coakley. They were on a public walk or sidewalk. Again, it is, honest to God, this is talking about a traditional public forum. That's why it's written in the way it is. I know you don't want to believe that, and that's fine. You hang on to that. You fight, baby, you fight. But at this point, Turner v. Driver is about traditional public forums. It's about filming the police from the sidewalk or a street or a park or a plaza. Ultimately, it's about filming the police. Now, in Leon Valley, it wasn't about filming. You may notice the guy with the flag didn't have a camera. And he, I believe, is the last one still in jail for blocking that doorway. Blocking the doorway is not a statute that's aimed at the suppression of speech. And even if it was aimed at the suppression of speech, it's not in a public forum. It is not. Whatever it is, I'm not saying that anybody should get arrested on that blocking the public or blocking the highway or access way or whatever the hell it was. I forget what it's called at this point because it doesn't really matter. Until I look it up, I can't tell you if there is any chance of them getting actually convicted on it. But at this point, it's not a First Amendment issue. I know you want it to be. You desperately want it to be because that fits your narrative. But everybody was filming all over the place. You were filming in that entryway and you weren't arrested. Riddle me that, Batman. If you weren't arrested for filming in there, why were they if it was for filming? It wasn't. That's why. I mean, give me a break. I don't understand how stupid you expect us to be, that you think that you can trespass with a camera. Oh, wait, but I've got a camera, so I can trespass. No, dude, you're trespassing. It doesn't matter if you do it with a camera or without. Oh, I can totally disrupt the court because I've got a camera, so I'm expressing my First Amendment right. No, dude, you're being disruptive. They're two totally... It doesn't matter if you have a camera when you're breaking the law. Breaking the law with a camera doesn't give you a shield. Oh, I was robbing a bank. Oh, no. I was filming it while I was doing it. It's First Amendment expression. It's a protected activity. That's retarded. Nobody's buying your line. It's not a violation of Turner v. Driver. They weren't in public, as in a traditional public forum. The analysis of Turner v. Driver does not apply inside a police station. Probably. It definitely doesn't apply inside of a courthouse. And they weren't arrested for filming. They were arrested for obstructing a doorway, which is a content neutral, viewpoint neutral, non-First Amendment related kind of activity. You don't get to block a doorway as First Amendment speech. You don't. I'm not saying they're guilty of it. I don't know. But blocking a highway or a doorway is not something that you get away with because you have a camera in your hand. Please, let's start being adults about this at some point. Please. And it's not all about you, Mr. Turner. You were a great auditor. You got legislation with your name on it. And for that, I am eternally grateful. You have done a great thing, sir. By getting Turner v. Driver, people should no longer be harassed. And if they are harassed simply for filming in public, meaning a traditional public forum, now the police are no longer shielded by qualified immunity. So you have done a great thing. You've done a great service. But your ego is a little high there, sir. Or your understanding of your own case is a little low. I don't know which is worse for you, but neither is complimentary. Anyway, thanks for watching. Have a great day.